everyone, this is Veronica and today we are going to talk about Supreme Court's latest verdict on BT Cotton. What is this case? We'll discuss in detail. For my video updates, you can follow me on Instagram and the PDF will be uploaded on my Facebook profile and the Telegram channel. So guys, this is channel StudyIQ. If you're preparing for any government exam, our pen drive and tablet courses are also available. For additional information, you can call on these numbers or you can visit our website. So now, what is the relevance of this topic in your exam from objective level where MCQs are asked? So basics of IPR, GM, GAC, you should know about them. We'll discuss them in this lecture. And the subjective level, what is the impact of the Supreme Court ruling on intellectual property right? It's very important for the environment paper, so it could be asked. Now, why it is in news? Because of lately Supreme Court had restored Monsanto company. So this is a company, a biotechnological company, and now it is not Monsanto, it is Monsanto Bayer, because it has been overtaken by another company, other big giant Bayer. So now it is Monsanto Bayer. So by the time at the time when this case was filed, it was Monsanto, so we'll say it Monsanto here only. So Supreme Court has restored its patent claim on GM, that is genetically modified BT cotton, until its validity. So until Delhi High Court decides like till what period this patent is valid, till then they can enjoy their patent rights in India. So this comes as a victory for Monsanto here. So we'll discuss this case, but before that I want to tell you some basics, the terms that we are going to use here, like what are GM crops, status of genetically modified crops in India. And about GM crops, I have talked in my various videos where you do certain genetic manipulations in the DNA of crops are known as genetically modified crops, and in certain videos I have talked about their advantages and disadvantages also. So here about the status of GM crops in India, you should know that India has the world's 5th largest GM crop acreage in our country. So the world order is like USA is the number 1, then we have Brazil, then we have Argentina, and then we have Canada, and then it comes to our country India. But you know what's the irony here, what's interesting here? Then let me add another fact on this, that this rank of India, that is the 5th, is largely on the strength of BT cotton. So it depends upon the strength of our BT cotton. And you know what, BT cotton is the only genetically modified crop allowed in the country, right? So at present 96% of cotton cultivation area is under BT cotton crops in our country. Then when we come to GAC, that is Genetic Engineering Appraisal Committee. So GEAC, this is an apex body under the Ministry of Environment, Forest and Climate Change for regulating manufacturing, use, import, whatever is related to genetic crops in our country, whether they are imports, exports, storage of hazardous microorganisms or GMOs, that are your genetically engineered organisms and the cells in the country. Everything is managed by this committee, and it is also responsible for giving technical approval of proposals relating to release of whether a GMO will be released in a country or not, or its products will be released or not. So everything is given an approval by this committee. However, Environment Minister gives final approval for GMOs, right? Ultimately the power is in the hand of Environment Minister, but it has to be passed by this committee. Now what is BT here? We are saying BT cotton. So now BT is Bacillus thuringiensis. Here it should be underlined or it should be written in italics. So here it is a mistake, so let me underline it. So now see, Bacillus thuringiensis is a bacterium that occurs naturally in the soil and it produces proteins that kill certain insects. Now through biotechnology, scientists can use this naturally occurring BT proteins to develop insect protected crops and protect against insect damage and destruction. So this is the use of this BT cotton also. And now when targeted insects eat the plant containing this particular protein produced by BT, this bacillus, they ultimately die. But impact of BT on humans and other animals is still being questioned. So that is why whenever any new GM technology is coming to India, there are a lot of apprehensions. So now let's move to the background of this news where Supreme Court has heard certain thing. that Supreme Court has restored Monsanto's patent claim in our country. Now it ought to reassure biotech companies that had held back on introducing new technologies in India after the controversy, because they were afraid now that they won't be able to earn much money in India because of our legal things. So let's go into the background of this case. Now see, the ruling is a result of a legal battle. So there was a legal battle between two companies. One was Monsanto and other was our domestic seed companies, which was led by Nuzividu Seeds. Right. So now see, what is the case? What happened back in 2004? Monsanto entered into sub-license agreement with our domestic companies, like Nuzividu is one of them, and there were more companies also, for initial period of 10 years. Right. Now the agreement had entitled the Indian firms to commercially exploit genetically modified hybrid cotton planting seeds with help of Monsanto's technology within the limits of agreement, and these Indian companies had to pay them a license fee. Right. So now local seed firms which get licenses from Monsanto to sell genetically modified seeds used to pay a trait fee. So they used to give this trait fee. This trait fee is like a royalty which was fixed by Government of India. Now recently what happened, these Indian companies, which includes Nuzividu Seeds also, they were arguing that US company, Monsanto is a US based company, it was not entitled to get any more money from them, and had petitioned in the court to cancel this US based Monsanto's patent. Now soon after, Monsanto had also lodged a counter cases on patent infringements by Indian companies. Now what happened, this agreement was terminated by both the companies. Whatever the agreement they have signed back in 2004, it got terminated in November 2015. So they give rise to the patent suit. Now what happened in 2017, the single judge in March 2017, they restored the agreement and they ordered the parties. So who are the parties? Monsanto and the companies, Indian companies, to adhere to their obligations under it. So this case was in Delhi High Court. So now why did Delhi High Court rejected the patent of Monsanto? So this thing you need to understand here. The judge gave the reason, the judge reasoned that Monsanto's BT gene was useless to farmers unless it is inserted into a cotton hybrid, which farmers could then grow to repel pests. So what is the thing here? Monsanto, they have identified this particular gene in Bacillus, which is useful, which is the main thing here. But this gene, whether you identify any gene, until you are implementing the technology somewhere, it is totally useless. That is what Supreme Court said. So until you insert this particular gene into a cotton hybrid, it has no use to farmers, right? So this insertion is carried out by seed companies, which are Indian companies, who cross this BT containing plant from Monsanto donor with their own cotton varieties. Now the judge argued that this crossing of plants was a natural and biological process, because you are growing one plant with the Monsanto seed and then you are growing your homegrown plant and then you are crossing these plants. So Supreme Court said that this is a natural and a biological process. So this argument undermined Monsanto's patent. Why? Because in India, there is a patent, India's Patent Act, and it's section 3J, right? It is written there, a seed or a plant or a biological process to create a seed or plant cannot be patented. So this technology, on which the Monsanto was asking the patent, so according to India's Patent Act, it cannot be patented. So if this argument is correct, few plant biotechnology innovations could be patentable in India. So because most of the biotechnology innovations are like this only, like this one, where you identify the gene and then you insert it into another plant or wherever you want, right? So by this way we won't be able to patent a lot of things. So this is dangerous conclusion, because the lack of patent protection would discourage the important research and development that is growing in our agri biotech industry, because you already know about the farmers in our country, the agrarian distress we have. So one of the feature to remove this distress from the farmers is your research in biotechnology. But by this way, the companies will be discouraged to do this type of research. Now, what is the importance of this Supreme Court ruling? See, Supreme Court has validated that patents are integral innovation and they are very necessary to carry on the research and development and encourage such companies for such research that is required in the country. Now, technology developers will now be encouraged to invest more money because of the Supreme Court ruling. They have restored the patent. That is why it will encourage the technology developers to invest more money into bringing new technologies to the market. So the court has recognized that products of biotechnological processes, which processes like man-made DNA constructs, are now patentable in India. Now, the ruling may prompt some biotech companies to revive expansion plans that were placed on hold amid restrictions imposed by government, and even SC ruling will bring certainty in the policy environment of the country also, and looking to improve Indian cotton farmers' competitiveness. Right, so this is the importance of Supreme Court ruling. Now see, what are the basic issues that arise out of this case? One is your IPR issue, because protecting intellectual property right is vital to improve the competitiveness of Indian farmers. And here you can see that Supreme Court suggestion to Delhi High Court, a division. Why I am mentioning Delhi High Court here? Because this was the division bench of which had ruled that life forms cannot be patented. So that all aspects related to Monsanto's patents on genetically modified seeds can be considered, could allay apprehensions among technology developers over losing pricing freedom in India, and they won't come to India and they won't give new technologies to Indians, right? Then there's a issue of reduced royalty, because the government has capped royalty payments to Monsanto and asked it to grant license to more seed companies for using Bt cotton. So here the trade fee is something like if a plant it costs like rupees 740. So from it, like the rupees 39 or 49 you need to give to the company as your trade fee. So these companies, Indian companies, were asking Monsanto to reduce this fee, but they denied. That is why they filed a case and find out this Delhi High Court judgment was stated after that. So the government initially they have capped royalty payments to Monsanto and asked it to grant licenses to more seed companies for using Bt cotton. Now Indian seed companies pay a government mandated trade fee. So when it is government mandated, it is like known as trade fee. So this is similar to royalty, okay, on genetically modified seeds. Now these multinational biotechnology companies, like there is Monsanto, which has held back other Bt varieties from India, and Monsanto Bayer has gone slow in introducing hybrid rice that can withstand flooding for 2 weeks. So the main thing that I want to tell you here is, when you impose so many restrictions on these foreign companies, they stop themselves for introducing new technologies. They don't want to give new technologies to India because of the pricing mechanisms. Now field trials. So see, even in our country, a lot of people are against GM, even the government. Only this Bt cotton is allowed in our country. So regulatory clarity over field trials for genetically modified seed is overdue. So a moratorium on field trials for Bt brinjal, for instance, is in the 9th year, and the government wants more research done on GM mustard, which involves more field trials that in turn await permissions from state governments. So these things will be improved after this SC ruling, Supreme Court ruling. Now see, what is the way forward for such things in our country? Because transgenic technologies such as Bt cotton are an important part of India's cotton production. Right? They are not infallible. But this is true of all technologies, like whether they are antibiotics that sometimes fail when used improperly, as was the case with Bolgard too. Right? So the important thing for India to keep is to incentivize the development of such technologies, to encourage the research and development in this field, to use them properly, because strong patent protection is a crucial part of this process, right? Because if you're not going to protect the patent rights of the companies, the intellectual property rights of the company, nobody is going to take up research projects in this field, right? So we will lag behind from the world. So that is why we need to see that patent protection should be given importance in our country. So that is it. If you have any queries, you can contact me. PDF will be uploaded on the Telegram. Thank you.